Welcome back. In this final topic, we take up the question of employment at will. Employment at will, or at-will employment, is fundamental to understanding American employment law. The employment at will doctrine is the foundation of American employment law. All of the other laws that we think of when discussing employment law, whether that's the Fair Labor Standards Act, or the Occupational Safety and Health Act, or the National Labor Relations Act, Title VII of the Civil Rights Act of 1964, all of those employment statutes are essentially exceptions to the employment at will doctrine. So this is the foundational basis of American employment law. And what it says is that an employer can terminate an employee at any time, with or without cause, and with or without notice. At the same time, workers are free to quit their job for any reason, without notice or without cause. So the employment at will doctrine is supposed to be equivalent for both employer and employee. Now we're going to find out that this employment at will doctrine is primarily pro-employer, and so courts and state legislatures, federal legislatures, they have crafted numerous exceptions to at-will employment. What I do is always advise my clients to not over-depend on employment at will as an excuse when terminating an employee. So in this topic, what we're going to do is to better understand employment in the United States. We're going to look at the employment at will doctrine and its numerous exceptions. Now, where did employment at will come from? No one is quite sure, but it is rooted in that same doctrine that we have talked about before, freedom of contract. The idea being that the employer can contract with the employee and they can terminate that contract as well, just the same as the employee can terminate the contract whenever they want. And so this is the belief that freedom of contract makes things equal. And that's where we really see the roots of employment at will. Now, most employment agreements, most employment contracts can be terminated at any time. Employers may terminate employees even without cause, without facing a breach of contract claim, without incurring any liability for breach of contract. The classic restatement of the at-will rule is that an employer may discharge an employee for good cause, for no cause, or for bad cause without being guilty of a legal wrong. And this is the law. That is the law in 49 of the 50 states. Employment at will is a state law doctrine, and states differ in their approach to employment at will. Again, 49 of the 50 states recognize employment at will as the foundational employment doctrine. However, they treat it differently depending on the state. Some states have very narrow exceptions, while others have broader means that employees may use to avoid the doctrine. I said 49 out of 50. You may be wondering who the 50th state is. It is Montana. Montana is the only state that does not have at-will employment, meaning if you terminate someone in Montana, it must be for cause. They must have done something. So that's the foundational basis. Anyone can be discharged at any time for any reason, good reason, bad reason, or no reason at all. However, there are numerous exceptions to at-will employment, starting with a contract. An express employment contract between the parties can change the at-will employment relationship. The contract itself may specify the duration of the employment, as well as other terms and conditions of employment and termination. So whenever you hear about a contract with a defined term, for instance, when a new coach is hired at a university, where they're given a 3-year agreement, Well, that 3-year agreement, that term, takes it outside of the scope of employment at will. And so if there is a contract with a specified term of employment, then that is not an at-will relationship. A contract with a defined duration for employment takes the job outside of the doctrine of employment at will. You may also find collective bargaining agreements. Collective bargaining agreements are generally negotiated by unions, and they will often require just cause for termination. So even though the employee may not have signed an individual contract with the employer, the collective bargaining agreement in place puts in a just cause requirement. And most unionized workforces will have such a provision in their collective bargaining agreement. Employee handbooks. Now, this is an area where we've seen a lot of activity across the country. This really started to become popular way back in the 1980s and 1990s as employee handbooks became a regular part of employment. And quite often the employee handbook will have a number of aspects to it that seem to resemble an employment contract. So the employee handbook may, for instance, have a grievance procedure that specifies how to make a grievance, how to complain about a position. It may have terms related to probationary employment, saying you're a probationary employee for the first 6 months of employment, after which you become a regular employee. And so all of those handbooks had those terms that kind of sounded like an employment contract. And so quite often employees will assert that the provisions found in an employee handbook created an implied contract. Now, most courts in the country have rejected this argument, and especially so since most employee handbooks now contain a disclaimer that says this is not an employee agreement, you are an at-will employee. Generally, every employee handbook contains some provision in there regarding at-will employment. Nevertheless, I should point out that Oklahoma has signaled that sometimes an employee handbook may rise to the level of an employment contract. Let's look at this case of Russell versus Board of County Commissioners, Carter County, a 1997 case out of the Oklahoma Supreme Court. Now, in this case, the Oklahoma Supreme Court ruled that an employee handbook may, in certain circumstances, serve as the foundation of a contract. Now, in this case, 10 Carter County Sheriff's deputies sued the Board of County Commissioners for breach of an employment contract in order to obtain overtime money that they said was theirs under an at-will employment agreement. Now, the deputies were categorized by the board as being on the sheriff's personal staff. And if that was true, then the deputies were not covered by the Fair Labor Standards Act overtime regulations because of that categorization. In reply, the deputies asserted that the commissioners had developed standard personnel policies for county employees and made those regulations available to county employees in a handbook that reflected the board's practice of paying overtime to county employees. The deputies believed they were entitled to the overtime and holiday pay under the terms of the handbook. They argued that the county, by refusing to pay the overtime compensation, violated the employee handbook, which was a part of their contractual agreement. The board insisted the contract was not that the employee handbook was not a contract. In fact, there was a disclaimer in there in which it was explained that it was not an employment agreement. Nevertheless, the Oklahoma Supreme Court found that the disclaimer was ineffective because it was not sure that the board, the employer, had always acted in a manner consistent with the notion that the employee handbook was not a contract. And so the court pointed out that Oklahoma law permits an employee handbook to result in an implied contract if the standards for a contract are there: mutual agreement, a lawful object, competent parties, and consideration. Let's talk about common law protections of employees, common law provisions, common law exceptions to the employment at will doctrine. Now, the employment at will rule is pro-employer, and thus courts have recognized that if they strictly apply employment at will, it could result in unfair treatment of employees. Therefore, there are three common law exceptions that are found, bits and pieces of them found in all of the states. Starting with the public policy exception, this is the most widespread exception to employment at will. The second is implied contract protection, and third, the covenant of good faith and fair dealing. Now, the public policy exception is where we will start, and I'll point out that Oklahoma has a strong public policy exception. Now, what is public policy? Well, public policy occurs when an employee is discharged for refusing to act in violation of an established and well-defined public policy. A public policy is meant to reflect things that a society wants to happen. And so if an employee is terminated for doing something which is good for society, then that may rise to the level of an exception to employment at will. A very famous case from a few years back involved a driver of an armored truck. Now, the driver had signed an agreement with his employer to never leave the truck unoccupied. Well, one day the driver was driving along. The driver was a registered EMT, by the way, and he saw an automobile accident, so he got out of the truck, he locked it, he went to the rescue of the people involved in the accident, and when he returned to his job, he was fired for violating the company policy against leaving the truck. Well, in this case, he sued for wrongful discharge based on the fact that he was doing something that we find positive for society, that if someone can rescue, then we want them to rescue without fear that they're going to lose their job over it. Now, there is a Kmart case here in Oklahoma which created essentially a whole new tort, and it's called Burke versus Kmart Corp. Now, in Burke, the court noted the limits of the at-will doctrine. The basis of the Burke case involved a sexual harassment claim by Miss Burke against her employer, Kmart Corp. She asserted that she'd been harassed on the job, and then when she complained about it, she felt retaliation for that, and so she eventually quit, believing that she had no alternative to and no ability to stay in that job. She sued for wrongful discharge, and Kmart responded with employment at will. She was an at-will employee that they could fire her for any reason they want, good reason, bad reason, or no reason at all. But the Oklahoma Supreme Court was a bit concerned about that. They said that the employment at will doctrine is not absolute, and that the interests of the people of Oklahoma are not best served by a marketplace of cutthroat business dealings where the law of the jungle is thinly clad in contractual lace. And so what the Supreme Court did, was to create essentially a tort, just as we talked about with tort. So it's a common law claim for wrongful discharge, not based on a contract, but based on violation of a tort, that because sexual harassment is against the law, and because it appeared that sexual harassment took place, one should not be fired for complaining about sexual harassment. Now, in this case, Miss Burke had another opportunity. She had a statutory claim under Title VII and under the Oklahoma Non-Discrimination Act. Nevertheless, she was permitted to pursue a common law claim. Now, public policy exception may be based on violation of a statute or an executive order. Public policy is established when a law is violated that protects the public from harm to their health, safety, and welfare. A recent case on this matter occurred here in Oklahoma a few years back. Ho versus Tulsa Spine and Specialty Hospital involved a nurse who worked for this hospital. Now, this was a case that arose during the time of COVID, and in 2020, the city of Tulsa established what was called the Safer at Home policy, which encouraged employees to stay home. And at the same time, the governor of the state of Oklahoma issued an executive order prohibiting all elective surgeries in Oklahoma for as long as the pandemic lasted. So what this meant was that if it was an emergency, you could get surgery, but if it was an elective surgery, meaning now is a good time as any to get your knee replaced or to have, your back operated on, you were not permitted to do so by terms of the executive order. Allegedly, Tulsa Spine and Specialty Hospital continued to operate on patients during this time period. The nurse, Ms. Ho, did not go back to work. She said that she would not go back to work until she was permitted to do so by the executive order. In any event, they terminated her when she failed to appear for work, and then she later filed this claim for wrongful discharge. And once again, the Oklahoma Supreme Court ruled in favor of the employee, holding that employment at will is not absolute, and in this case, the executive order established a public policy in Oklahoma to not permit elective surgeries. The breach of the implied covenant of good faith and fair dealing. Now, this is an argument that some states have taken up. Because every contract is said to have an implied covenant of good faith and fair dealing, there's the argument that employment contracts require good faith. And if an employer acts in a violation of good faith, if they act in bad faith, then they should be sanctioned for that. So this argument is that any agreement between the employer and the employee includes a promise that the parties will deal with each other fairly and in good faith. This, however, has not proven very popular among states. This exception is limited to a small number of states. And in Oklahoma, the Supreme Court has expressly held that there is no implied covenant of good faith and fair dealing in employment contracts in Oklahoma. Breach of an implied contract. Now, we mentioned this somewhat before when we were talking about employee handbooks. An implied contract arises out of the actions of the parties to the agreement. That if sometimes two parties' acts seem to indicate that there is an expectation of a defined term, if they create a reasonable expectation of continued employment, then the implied contract would apply and be an exception to employment at will. Now, again, employers can disclaim any existence of an implied contract, and they usually do that within the agreement itself that says that this is the entire agreement and we should not make reference to anything outside of this agreement. But again, their conduct has to be consistent with the disclaimer. Promissory estoppel. This is another legal doctrine that essentially says that when someone makes a promise that another party relies upon, then that party should be bound to follow through. And if they don't, then they should have to pay for the damages caused by the representation. Now, it's somewhat similar to implied contract, but implied contract implies that there's an actual contract. Promissory estoppel recognizes that there is no contract, but the employee can show that the employer made a promise upon which the worker reasonably relied to their detriment. Then they are entitled to what's called reliance damages. They are going to get whatever the damages were that accrued because of reliance on the promise. We call that detrimental reliance. The plaintiff relied on the promise to their detriment. The case in your book, Grouse versus Group Health Plan, this involves a case where a pharmacist applied for a job with a new company and was hired by the second company. The pharmacist notified the second company that he needed to give 2 weeks' notice to his current employer, and the second company, the new employer, said, "That's fine, we will see you in 2 weeks." Well, in a week or so, the second company decided that they could not wait for another pharmacist, and so they hired the number 2 person as their new hire. Another week later, and Mr. Grouse appears to show up for his first day at work, and he is informed that he does not have the job and that they have hired someone else in their stead. Now, they could have fired him at any time for any reason. This is what employment at will says. But in this case, he had undertaken to quit his former job, to move to a location closer to his new job, and so he had spent money, out-of-pocket damages, as a result of this promise that he relied upon. And so the court did not give him contractual damages, but he was given his reliance damages, the amount that he suffered because of the promise. Now, there are many statutory protections against employment at will, I should say. The employer's ability to terminate the relationship is limited by statute, starting with the most important one, anti-discrimination statutes. An employer cannot violate anti-discrimination laws. And in fact, that's what Title VII of the Civil Rights Act of 1964 says, that you can discriminate for any reason you want as long as that discrimination is not based upon membership in a protected group, that being race, color, sex, religion, or national origin. So an employer cannot discriminate on those bases. So that is outside of the scope of employment at will. Every state has their own version of Title VII as well, so this would apply to every state law as well. There is another statute called the Warren Statute. This was passed back in 1988, which was meant to protect employees and their families and communities by requiring an employer with 100 or more employees to provide 60 calendar day advance notification of closing and mass layoffs. And so the Warren Statute says that you must give 60 days notice if this is going to be a mass layoff. The employment at will doctrine does not apply in this particular situation. You may remember when Elon Musk bought Twitter and renamed it X and then immediately fired about 3/4 of the employees. Much was made about the fact that he was going to pay them 2 months worth of salary. Well, where that came from is the WARN Act, the Worker Adjustment and Retraining Notification Act. Finally, retaliation. An employer cannot terminate an employee in retaliation for exercising statutory rights. things such as filing an anti-discrimination claim or a claim for workers' comp for on-the-job injuries. If you are acting in furtherance of your statutory rights, you cannot be terminated for that. Somewhat related are whistleblower statutes. Whistleblower statutes they're both federal and state whistleblower statutes. The main federal statute called the False Claims Act, and it protects employees who report fraud against the government. The Whistleblower Protection Act also protects federal employees who report illegal or unethical conduct. The Fair Labor Standards Act, the FLSA, protects against retaliation for reporting wage and hour violations. And finally, Sarbanes-Oxley protects whistleblowers in publicly traded companies. States often have their own whistleblower statutes, and these vary greatly from state to state, so we're not going to spend a lot of time on it. These state statutes are usually specific to each state. They oftentimes reflect the same substance as the federal statutes and perhaps even provide additional protection for whistleblowers. State laws may provide the similar protections but differ in the available remedies. So, in conclusion, what do we learn in this lecture? An employer can make employment decisions that are not based on wrongful grounds. The law presumes that employees are hired as at-will employees, meaning unless there is a defined term of employment, you are an at-will employee. And finally, numerous exceptions to the employment at will doctrine exist. Please review these, and if you have any questions about anything, don't be afraid to reach out. I look forward to hearing from you. And that's it for this one. Thanks a lot.